Mr. Harris, I forgot to mention, we have to rise at 3:30 today, but it's all right because we're on track. We've got the half hour for slippage tomorrow, and we've got all of tomorrow afternoon, should we need it, because it's an important case. We've got to get through this today and tomorrow. So just to let you know, I'll be stopping at 3:30. Sorry about that, my fault.
No, well, thank you, and I'm very grateful. I've indicated to my friend Mr. Hoff that I'll try and stick to my 2:45 guillotine, and we will take from there. Can I start by telling you what I'm going to do? I'm going to give you an answer to the question posed before lunch. I'm going to address you very briefly on real and immediate risk and how to approach it. And then I'm going to give you a handful of propositions and then take you to some authorities to try and make good those propositions. That's the approach. And when I go to the authorities, I'm afraid it'll be in paragraph, quick summary of...
We've read quite a lot of them already, I think, actually some more than twice.
I'm grateful. Question, must there be an Article 2 compliant inquest if there's already been the ICE report in order to avoid a breach of convention, the procedural duty under Article 2? The question is entirely just because 5.2 of the Coroners Act reads as follows. It's you don't need to turn it up, so I'm going to read it out, but it's at page 14 of the authorities bundle. Where necessary, in order to avoid a breach of any convention rights within the meaning of the Human Rights Act, the purpose mentioned in 1B is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death. So the purpose of an investigation is to record how, when and where the deceased came by death, and where necessary in order to avoid a breach circumstances. So the question is it necessary to avoid a breach of procedural duty for there to be a Article 2 inquest, if it otherwise applies? The answer is yes, necessary, because the ICE report does not deal with a central issue in the inquest, namely causation. That's exactly the same point as in Ground 1. Second, there was no family participation in the ICE report. Third, the ICE report was a private investigation, not a public one. And just to demonstrate that the nature of that, some of the documents involved in that, including letters, forms and so on, are not available to the family. And also, finally, no prevention of future deaths role. One of the overarching points of an Article 2 inquest, from the point of view of the deceased family, is the hope that the same thing will not happen to somebody else. The reason the Article 2 procedural duty requires the how and in what circumstances to investigate those, and if necessary, in order with at least one view of lessons being learned. None of those purposes would be fulfilled simply by reliance on the ICE report. So yes, necessary. Second point, just introductory, I said in my summary of issues, one should break the question down into, is the operational obligation capable of applying to the particular facts? And as you know, I say these are shockingly bad facts for the DWP, because the word used by Divisional Court. And if so, that's the prior question, and then if so, was there arguably a real and immediate risk of suicide on the facts? Now on that, the first question, is it capable of applying, is really a question of law. That's the argument that's been put, and we agree it's a question of law whether it's the operation duty is capable of applying. But the question whether on the facts there's an arguable, on the facts there's a real immediate risk, is the arguability is the approach. And as to what real and immediate risk means in context, the answer to that is Rabone at paragraphs 38, I think it's 38 and 39. The reference in the bundle is at bundle 1 of the authorities, paragraph 38, 39, a little bit of 40. This is Lord Dyson, paragraph 38, Melanie's second sentence of first sentence. Paragraph 38 at page 649 of our authorities. The courts below were clearly right to say the risk of meningitis was real in this case. On the evidence of Dr. Kaplan, it was a substantial or significant risk and not remote or fanciful, the relevant words in apposition. And there's furthermore about what the psychiatrists agree. And then last, just below D, the risk was real enough for them to be of that opinion. I do not accept as Cast Frisk's submission that there had to be a likelihood or fairly high degree of risk. I've seen no support for that test in Strasbourg jurisprudence. And as to immediate, the argument was it had to be imminent, and from Van Cole, then INRI Officer L is mentioned, and an apt summary of the meaning of immediate risk is one that is present and continuing, and the agreement by Lord Dyson that the phrase present and continuing captures the essence of its meaning. So for real and immediate, we're looking at immediate means present and continuing, real is significant rather than fanciful. So arguably significant, arguably present and continuing, and we say that is satisfied on the evidence of the ICE report and Dr. Turner, on the certainly the arguability threshold.
Sorry, can Dr. Turner help on that? Because he didn't ever assess Jodie. We've really got to look. The only evidence we've got to find out whether there's a real and immediate risk. We've got some doctor's material, and we've got a summary of what the doctor said on certainly one, possibly two occasions when the doctor wrote, the GP that is, wrote to the coroner.
But
I mean, you'll take me through that, because I've got the paragraphs and I hear what you say about the meaning of them, but at some stage it will probably assist us to have you relate those paragraphs to the facts of this case, because the Rayburn case was different. She'd gone into a hospital, she'd been assessed as moderate to high risk, she'd cut her wrists, she'd put plaques around her neck, and then she'd been given leave to go home, where she killed herself, sadly. So we need to look at the facts at some stage.
My Lord, the answer to the risk is, firstly, I'd say Turner does help, because the nature of borderline personality.
Oh, we can help with understanding what that means, yes.
Yeah, and because of that, that's how you can properly conclude that the risk was a significant rather than a fanciful one, because the nature of the underlying condition was such that any external stressor, but in particular one such as this, might produce exaggerated effects and a negative effect on suicidal ideation, such that there was a credible, significant risk of suicide. And the present and continuing is that it was present and continuing throughout the whole period between September and her untimely death in February. May I just make one more point, backtracking slightly, because it's been pointed out to me that I may have made a concession too far, and that is simply on the they were discussing Dr. Turner's evidence, and the question about whether it was wrongly, the benefits were wrongly terminated or just terminated. Why does it matter? From our perspective, we think it is relevant that there is at least some evidence to suggest that she suspected that she was being badly treated or wrongly treated by the cessation of benefits, that it was a wrong decision. She suspected she was being poorly treated by DWP. There's some evidence to that effect in the transcript by reference to the note in a text message that is written. I don't really want to expand that too much, but it doesn't make that much difference to the overall.
If it doesn't make any difference, but if you're saying that the wrongfulness in the way that we now understand it from the ICE report played a part, you'll have to take us to that.
No, I'm not saying that. I am saying just as if one gets a parking ticket when one thinks one's parked at 6:05.
But Jodie didn't think she'd had the letter. She thought she hadn't had the letter.
She thought there was something wrong with having her benefits terminated, and it was wrong to terminate on the basis of, because she hadn't had the letter. She thought there was some procedural error had resulted in her loss of benefits.
She didn't expect it because she hadn't had anything in her mind to tell her to go to the assessment. Is it more than that?
No, it isn't.
No, okay.
The Article 2, if I may start then by saying that I'm going to give you some propositions. I repeat that which I said earlier before lunch about our general approach. We accept no general obligation on the state to prevent a person committing suicide, and that's clear from the authorities, even if the authorities know or ought to know of a real immediate risk, and we'll see that that's what Lady Hale says in paragraph 100 of Rabone. The right approach is that the state has a duty to protect against self-harm only in particular circumstances. In our cases, these particular circumstances are shockingly bad set of circumstances sufficient to give rise to the Article 2 obligation. So no general duty, but particular circumstances can have that consequence. As to general approach, and the proposition which you'll see from the authority I'll take in a moment, in cases of sufficient vulnerability, there can be a breach of the operational duty, even where there is no assumption of control. And the classic example, you see it in Rabone, is the failure to exercise powers to protect a child who the local authority knows is at risk. In the case of Z, I think in the United Kingdom is given. And so sufficient, so you don't need to have the control. In any event, control in the sense of confinement, detention or constriction are, we agree, paradigm examples of control. But what the cases show is, depending upon the nature of the vulnerability of the victim and obviously the particular circumstances, that degree of control and responsibility varies across the cases. And I'll show you how you don't need to have full control, nonetheless to still owe the operational obligation. And a final proposition is that the operator, and picks up on something that Lady Hale says in there as well, is that operational duties under both Article 2 and 3 are similar, if not identical. In other words, that there's an obligation when you're exposed to inhuman degrading treatment with a threshold, then it's likely that a similar obligation may apply in an Article 2 case arising out of similar circumstances. Now, I won't do justice to the number of authorities, but it's important to try and focus on really what my case is, and to do that, may I just take you to a handful of the key cases. First of all, Gardner, because this is the COVID case, relatively recent, quite a useful synthesis of approach, both in the argument and the decision. So Gardner is to be found at Bundle 2, tab 43, page 1106. And this was a case about operational duty to protect life. And essentially the whole, it was a very widely drawn obligation, as was argued for. If I can just jump in straight at paragraph 228, which follows a discussion of Article 2, we see under the heading operational duty a summary of the detailed grounds offence drafted by Sir James Eadie and his juniors. Common ground, 3 key factors to be present for Article 2 operational duty to apply. 1, real and immediate risk to life.
Where are we reading from?
Sorry. 1149. Sorry. Paragraph 228.
Yeah, that's right, okay. Oh, so just 228, not 228. Sorry, I got you, yes.
Sorry.
Yes, I'm with you now, I understand.
I was trying to go fast, and I apologise. The operational duty at H is summarised by reference to 3 key factors. Real and immediate risk to life. My lord, have I confused?
No, you got me now. I thought it was 2, then the words 28, so I looked at paragraph 2, the second paragraph.
Sorry.
But you were saying 228, not 228.
Yeah,
that's all. It's my fault. I'm a very simple brain. Yeah.
I apologise.
I'm with you now, yeah.
228, it is at H, it's common ground, the key factors must be present in order for Article 2 to apply. Real and immediate risk to life, actual or constructive knowledge of the state of the risk. So they knew about, in our case, yes, we say real immediate risk to life, arguably, at least arguably so. Actual or constructive knowledge, yes, they knew of the suicide risk. 3, a sufficient connection or link with the responsibility of the state, and linkage between the risk that you're supposed to be guarding against, suicide, and the state responsibility in that particular risk. And we've seen from the vulnerability and safeguarding documents that there is a responsibility on the DWP, knowing of the risk of suicide, to take particular steps to mitigate or reduce that risk. So that's the first point at 228. At 231, I'm just dropping this in because in the skeleton against me it said well-defined circumstances is repeatedly found in the authorities, and all I would say is, as Lord Justice Bean says here, when Osborne said in certain well-defined circumstances, it can't be said that those circumstances remain well-defined, clearly nearly a quarter of a century later, and principles can be said in broad terms. But I move swiftly on to 250, which is where the court gives its conclusion on the operational duty and draws the following from the domestic and Strasbourg cases. 1, real and immediate risk to life is a necessary but not sufficient factor. 2, generally the other necessary factor is assumption by the state of responsibility for the welfare and safety of particular individuals, of whom prisoners, detainees, mental health, immigration detainees, conscripts are paradigm examples. 3, however, the duty may exist even in the absence of assumption by the state of responsibility where the state or municipal authorities have become aware of dangerous situations involving specific threats to life which arise exceptionally from risks posed by the violent and unlawful acts of others. And then 4, what suggests that in appropriate circumstances which remain so far undefined, the operational duty may also arise where the state or municipal authorities engage in activities which they know or should know pose a real and immediate risk, according to a ground exceptional risk, to the life of a vulnerable individual or group of individuals. So a range of different recognised categories are identified by the court in that case. Now, to fully understand my case, it is to show you that through a series of cases, the courts have developed an approach where, without confinement or control in the detainee sense, being detained or conscription sense, there can nonetheless be an operational duty where a sufficient degree or a degree of control is operated over the individual. Now, the way that the...
Before we leave Gardner, it's quite helpful to know what they did in the end, because what they did often helps one understand the words that they used. And it's not always helpful to take sentences out of context and say, there we are, that's a word, and that word applies here. Because I thought they said that there wasn't a duty here, so why wasn't there a duty?
Because the class was so wide, which was being directed against.
Ah, right. Which paragraph is that?
Can we look at 252?
Right.
I mean,
Because it's all people moved to care homes
yeah,
from hospital in the pandemic.
yeah. It's the whole. It's a very broad and undefined section of the population. There is no clear and consistent line of Strasbourg which indicates that such a duty exists, and we cannot be at all confident, indeed we gravely doubt, that the European Court would be willing to declare that it does. We should keep pace with Strasbourg but not run past.
Okay, so that's that, right. Just so that I know what it was that they understood by the words in that context, right, okay.
Can I take you briefly to Honor Yildiz, which is the case about the tip. That's at 170. It may not be. I'll do this as swiftly as I can. 173 of the initial bundle of authorities. First bundle of authorities.
Tab 11.
Tab 11. This was facts summarised in the head note at page 135. Living in a slum bordering on a municipal tip. There was an methane explosion killing relatives. Held unanimously there'd been a violation of the substantive aspect of Article 2 due to the lack of appropriate steps to prevent the accidental death of the relatives. Key paragraph 101, page 172 of the authorities bundle. That the Grand Chamber agrees that the administrative and municipal departments responsible for managing the tip, it was impossible for them not to have known of the risks, particularly as there were specific regulations. Bottom of the page, they knew or ought to have known there was a real and immediate risk to a number of persons living nearby. And at the top of the next page, they constantly had a positive obligation to take such preventive operational measures as they were necessary and sufficient to protect this risk, especially as they themselves had set up the site and authorised the operation which gave rise to this in question. So creating a danger can trigger the operation. In Watts, another case reviewed, and what
is that directly analogous here? I mean, they didn't create the danger in the way that the authorities did there. There were regulations governing the management of tips, and they set it up, and they didn't apply their own regulations, it seems, to the tip they set up. That seems a very far cry for the situation here.
Well, what can I say?
Oh, okay.
I do draw an analogy in this way. There's a positive, going back to my bullet points, there's a positive acts or omissions by which the state agents created or exacerbated the risk of suicide or increased the risk of suicide by their own actions. That's the crossover I draw from that. There's a role of the state here in doing so.
So you want Watts?
Watts, it's going to be paragraphs 82 and 3. It's authorities bundle, page 455. You've seen a reference to it as drawing some strings from it in the case. The relevant paragraph 82 to 3. this was moving between care homes and increased risk to her life from moving. Paragraph 82, the emergence of the duties explained, bottom 3 lines of page 4, the photocopy page 477. It's since made clear that the positive obligations are engaged in the context of any activity, whether public or not, in which the right may be at stake, and then says for the court to find the violation of the positive obligation, it must be established as new or ought to have known at the time of the existence of a real meal and means to life of an identified individual, and that they failed to take measure in the scope of their powers, which judge reasonably might have been expected to avoid that risk. Now, I'm not going to say much more about that until we've seen what Lady Hale makes of that in Rabot, but you'll see that there's questioning as to, well, come on, that's much too wide. It can't mean that and apply to all situations, and I'll deal with that in a moment. Crucially for my case, and the case on which I place much store, is Mammadov. Which
well, before we get there, I mean, we do have to look at Article 85, which is against you. The extent to which the transfer of the applicant to another care home. She was in care, she was 96. I can't remember whether she had underlying problems or whether she was hale and hearty 96-year-old. But they're going to move her, they're going to close the care home and shift her to another one. And then she's got to look at that, and then they find that there's no risk. Then at 88, they say, which is what you rely on, I imagine, a badly managed transfer.
Yeah,
an elderly resident of a care home could well have a negative impact. But here, there wasn't going to be a badly managed one because they'd assessed them all. They were going to go, 4 of them were going to go together. Mrs. Watson, her 3 friends, were off together.
Agreed.
So we do need to take all of that into account. But you say that it's paragraph 83 and 88 you really rely on, I think.
It's 83 and 88 where it's possible that it applies.
Yeah.
On the particular facts, it didn't apply because they weren't satisfied.
Well, it did apply, but it wasn't breached.
It wasn't breached.
Which is rather different. You want that. Anyway, you wanted, the other one,
Mammadov. This is head note and at page Authorities Bundle 683.
This is your key case, so let's take this one a bit slowly. Let me just get the name right, first of all. Mammadov
in Azerbaijan. A case discussed in the bone. Head note tells you the facts. They were internally displaced persons. They fled their place of residence. They were occupying some rooms in an administrative building, and there was an attempt at their eviction without court order. Some police officers attended, and during that visit with the police officers in attendance, the applicant's wife, CM, set fire to herself, and the family's possessions were transferred back to the hostel. At paragraph...
Well, hold on, I'm reading further. On the 26th of March, he was asked immediately to vacate the premises in the presence of 25 to 30 police officers armed with batons. When he refused, force was used against the applicant and his mother-in-law, who had been treated in 1999 for hysterical psychosis and was in a state of shock and threatened to set fire to herself. They were not taken seriously. She was taunted by the police officers present. Gosh. And then she set fire to herself, and none of the officers attempted to rescue her. Gosh. Yeah.
Yeah. My lord, undoubtedly a shocking case on its facts, but can I say what I try and draw from that? At paragraph 111 to 115, there's the 111 is picking up on the end of a discussion as to whether there was the process of eviction was lawful or not. In other words, there was a court order allowing for eviction, and that wasn't crucial, as is said under 111. The court considers that by conducting the operation to evict the applicant's family, whether lawfully or not, the authorities could not be considered to have intentionally put the life of the applicant's wife at risk or otherwise caused to commit suicide. The court considers that, reasonably speaking, self-immolation as a protest tactic does not constitute predictable or reasonable conduct in the context of eviction from a legally occupied dwelling even in the situation involving such a particularly vulnerable sector as refugees. And going on, Wood couldn't have reasonably anticipated that she might react by committing suicide. There is no evidence to suggest that the state agents involved had been aware or should have been aware of CM's state of mental health. And therefore, the court finds that the authority's decision to evict the appellant from the dwelling, whether or not it did not in itself engage the state's responsibility of the convention. And they say it's insufficient to this requisite standard of proof that the state agents involved, incited or otherwise. However, 13, under Article 2 is not limited to only the above considerations. The court considers the principal issue in the present case stems from the fact that during the process of eviction, the events unfolded in an unpredictable way, and the state agents were suddenly confronted with a situation which their demands to vacate the building were met with an act of self-immolation by the applicant's wife. In this context, it's necessary to determine whether this specific situation triggered the state's positive obligation under Article 8. That is, whether at some point during the course of the operation, the state agents became aware, or ought to become aware, that CM posed a real and immediate risk of suicide, and if so, whether they did all they reasonably could have done. And then goes on to say that in terms of control, 114, in a police operation with the aim of eviction, the police are expected to place the flow of events under their control to a certain degree. And in the present case, CM's actions, however unpredictable or unreasonable they might have seemed, constitute a direct response to the state agent's demands and actions. And then this at 115, the court considers in a situation where an individual threatens to take his own life in plain view of state agents, and moreover, where this threat is an emotional reaction directly induced by the state agent's actions or demands, that should treat this threat with the utmost seriousness, constituting an imminent risk to the individual's life, regardless of what is expected. In the court's opinion, in such a situation, as in the present case, if the state agent become aware of such a threat, sufficient time in advance, a positive obligation arises under Article 2, requiring them to prevent this threat from materialising by any means which are reasonable and feasible in circumstances. Now, against me will be said, this is far removed from the factual situation which we're confronted, and therefore no discernible principle can be derived from it which applies. But my argument is that, or our argument, is that in fact what it shows is that we're now outside confinement, we're in the community, we have a known risk of suicide, and we have the state agents' actions who are exercising a degree of control, not total control, over the flow of events, precipitating or exacerbating the situation such that the victim commits an act of self-immolation. Therefore, this is an example of the court saying, in a shocking set of facts, where the particular circumstances are that a state agent has had some degree of control over the welfare of the individual.
Well, degree of control over events, whether that's the same.
Well, I'm going to show you in a moment Palestinian territories where... Yeah.
Anyway, sorry, I didn't want to...
the submission is going to be that control over events, the welfare of the individual, such that it triggers the obligation. And can I, without going to Rabone, which we've covered in the authorities, and partly with 1 hour at a time, can I take you straight away to Palestinian territories, just to see how that, what principle is derived from that little passage?
Right, so it's outside confinement, known risk is in the community, known risk of suicide, a degree of control over the welfare of individuals is sufficient to give rise to a duty, and you say it's the same here, all three things, different facts, the same principles.
Exactly, and can I see that point is distilled, or that approach is distilled in Palestinian territories, which is tab 40, page 1009.
Sorry, can you page reference again?
Sorry, one it should be in bundle 2. So I've given the wrong reference.
No, it is.
No, you've got it right. 1009. 1009.
Sorry, thank you. 1009. Yes, tab 4040. Head note for summary of facts includes Palestinian national, granted asylum in the UK, issued biometric residence permit, date of birth 19th of April 1989, thought to be the most likely of age. However, claimant suffers depression and PTSD, believes that the date was some 5 years different. Finding the imposition of what he believed to be an incorrect date of birth created by the Home Office to be deeply dehumanising and corrosive of identity, he began a hunger strike which resulted in being admitted to hospital. He sought judicial review of the refusal to amend the date of birth. And within this decision is a consideration and discussion of the role of hunger strike in relation to the role of Article 2. And what the court says in general terms, as at 60, because it's going to be put against me, paragraph 61 at D, we see the facts on the argument that's being advanced.
Can I just I do remember this case because I granted permission to appeal. It was a very unusual and very, very sad case. He had a psychological or psychiatric belief that he had to have been born on a certain date because he believed to deny that would be to deny his grandmother and to deny lots of things. Yeah. And I just can't remember, had he said that he would commit suicide? Yes, he'd gone on hunger strike, hadn't he?
He'd gone on hunger strike.
Yeah. So there was the decision that he was born on the date that he didn't agree with, and then he went on hunger strike at 19.
Yeah. Well, the discussion begins at 60 with the words, when someone makes a serious and sustained attempt to take their own life.
Yeah, but you can't read those words at 60 without understanding what they are talking about.
I agree.
So I'm looking at 19.
Yeah.
He went to volunteer, he was rejected because of his date of birth. He then had I can't remember what his mental state problems were, actually. And then he refused to, yes, that's right, he refused foods and fluid.
Yeah.
His health became, my recollection was that he said unless they changed the date, he'd kill himself, as I remember.
Correct.
And he was arguing that they've got to change the date, because if they don't change the date, I'm going to kill myself.
Indeed.
Yeah, okay.
There's a risk of self-killing, and those are the underlying facts which he's intent on pursuing, and the authorities are aware of the risk, and the question is whether they are, what steps they will be taking to, if any, under Article 2 to prevent
That's right, because I remember now, paragraph 21, he'd agreed to have a nasogastric tube until the outcome of the consideration. Yeah. And there was a decision in the High Court, and then I granted permission and I expedited it so that the court could deal quickly with the case. So that was the circumstance. A person was in the process of denying himself food and water in order to kill himself because of his disagreement with the date of birth. Yeah.
Correct. So it begins at 6. The discussion is at 60. This is Phillips. Yeah. When someone makes a serious and sustained attempt to take their own life, they may well come within the care or control of a branch of the state. And there's an argument in this case about which body and so on. And the argument is then recited at 61. If the cause of the claimant's suicidal intentions is deep unhappiness, whether or not justified with an administrative decision of another branch, that branch is obliged to take proportionate steps to change the decision. And that was really the argument. I'm hunger striking, so you've got to change my date of birth. And this is considered. And it's acknowledged by the court that if that kind of argument could have wide implications, you see it between D&E the range of administrative decisions which might have to be reconsidered and reversed in this scenario is obviously wide, and you can see that dealt with. At 62, in my judgment, no obligation to review administrative decisions in such will usually arise under Article 2. Emphasis on the word we say usually. The state body undertaking such administrative matters, such as the Home Secretary, will not have assumed responsibility for the welfare and safety of the patient and will not have a role in addressing the aspects that render the patient vulnerable, usually. But then reading on with paragraph 64, WA relies on the broadly worded statements in Mammadov and Lady Hale in Rabone as to the existence of an operational duty when the state knows or ought to know of a threat to life. However, those statements were made in the context of considering when a duty arose, not the scope of the duty by which branch of the state it was to be performed. In Mammadov, the operational duty plainly fell to be performed by police officers who attempted to evict the suicidal wife. They were the state agents exerting authority and control and had responsibility for the welfare of the occupants in so doing. And then says in the same way, it's plain that Baroness Hales had in mind the operational duty would be imposed on and performed by the authority for the welfare of the vulnerable. Now, our point is that the principle that comes out of Mammadov and is recognised here by Phillips is that there are circumstances where one looks at the state agent who is doing some act or omission, in our case, taking a decision to cease all benefits, and just as the police officers in Mammadov, so the DWP are the persons knowing of the risk who take the positive step to cancel benefits, were exercising authority and control and had responsibility for the welfare of the benefits, in this case, Jodie, in so doing. Now, why do I say they had authority and control and had responsibility for the welfare of Jodie? Because their own safeguarding policies show that there's a procedure that must or should be followed to protect the welfare of the vulnerable person at suicide risk. So in that regard, they did have the necessary degree of control. Indeed, it was only the DWP who could, if they applied their procedures properly, reverse the decision. This wasn't a healthcare situation. The risk was created, we say, by the cessation decision and the requirement to come for a face-to-face assessment. It was compounded by the other failings. And they had the necessary degree of control over the purse strings of benefits and so on, and the risk of suicide exacerbated by the withdrawal of benefits, to put them under a positive obligation to take steps within their competence, and we know what steps they are because they're in their guidance, to reduce or mitigate or remove that risk. And they didn't do so, and those were reasonable steps. That's how the argument is essentially put, arising from Mammadov. Now, I have hit 2:45.
But before you do, just one question, actually. Do we know from the documents that are before this court, because we looked at the brief this morning, whether you're put into the support group and there's a mental health flag because of the risk of suicide or because of wider mental health concerns? I know the particular facts about Jodie and what the doctors wrote and so on, but for this court, do we know what the position is as to which people are put into the support group and why, and which people are put on the mental health flag and why?
I'm afraid my reading of that policy is there's a single definition of vulnerability. But whether I'm right in saying that from the guidance, the vulnerability guidance, whether that is sufficient to get you in the support group, identifying those characteristics or not, I cannot answer without further research.
Because we've got to assess what you say, and that means looking at the policy which we put them in. As I said this morning, Jodie's in the support group, and also there's a mental health flag.
Yeah.
But that seems to be connected to whether your mental health issues as such, you're not going to be able to work and you're not going to be able to attend an assessment.
Yeah.
And I don't know whether that's enough to say, therefore they must have known. Now, for Jodie, you've got the letters from the doctor and what she put on the form herself. She said she's had enough.
Yeah.
You know, if the doctors can't do something,
Yeah.
I'm going to kill myself. So we've got that evidence too, but it is quite important to look at the other evidence. So for the policy, you say we can get it from, so all we're going to get in this court by way of evidence is the ICE description and the FOI
FOI response, and there is some policy behind that statement of Mary Varney's.
Yes, the FOI request document.
Yeah, behind it there is the vulnerability guidance.
Yeah, those are the two documents that are the documentary evidence.
But you will find when you try and study them, it's actually quite difficult to tease out what the answer to the question you just asked, or at least I can't answer it based on my
But in that case, that may mean that those documents don't evidence enough. And then we'll have to look at Jodie's own forms, the ones that she completed, and what the GP wrote. Because there was Jodie's letter, well, there's more than one actually. Yeah. There's the 2014 and the 2016 one. Yeah. And there was the GP letter that went as well. So we'll have to look at all of that to see whether that meets the requirements you identified. Yeah. Right, so that's what I wanted to ask, just to check. And am I right in thinking there is the material that Jodie sent? She completed the form in 2014 and 2016, and there was the GP response in 2014 and again in 2016.
That's my understanding of the ICE report, of a record. I don't have those documents. We don't.
No, but they're summarised in there. But that's what I've got to rely on. I've got Jodie's two sets of responses, and I've got a description of two letters sent by the GP,
Indeed.
2014 and 2016. Indeed. That's helpful. Thank you very much. That is helpful.
My Lord, I'm going to abide by my guillotine. I haven't. The way may I make this proposal that I simply, in 2 or 3 minutes, just summarise.
Why don't we give you 10 minutes? We're stopping a bit earlier, so we'll have to take up the half hour tomorrow. If we have to go into tomorrow afternoon, I'd rather hear everything that needs to be said on behalf of Jodie. She's not here, she can't speak for herself. So you speak for her and you tell us, you take another 10 minutes. Or up to 10 minutes as you want.
Well, I'll take up to.
Oh, you're not obliged to, no. But I just don't want I want Jodie to have I want Jodie's family to have every chance to make sure that they've told us what they need to know. So you have up to 10 minutes and see where we go. If you don't need it, because you've actually covered most of it, I think.
I have, but I didn't want to finish anything up without showing you the Rabone passages about development of increment, and then I can probably deal with the others by simply footnote points. Rabone itself is in the authority on page 630. I've already taken you to the passage on real immediate risk at paragraph 38. At paragraphs 19 to 21, is the review of cases where the operational duty applies.
Yeah.
These, we are not in a medical case situation, so I'm leaving to one side really the discussion about Savage and Powell, although simply to say that Savage to some extent foresaw the later developments of the Strasbourg jurisprudence in the later case law. And at 21, the essential features are what are looked at, and the indicia are then referred to at 22. And key wording that we point to at the bottom of H, this is both Ms. Richards and Mr. Bowen saying the assumption of responsibility by the state for the individual's welfare and safety, brackets, including by the exercise of control, as it's to say that that is but one way of the assumption of responsibility arising. And the paradigm example is then given of detainees, and the examples then given. The next indication or indicia is at paragraph 23, the vulnerability of the victim, and that can apply where there's no assumption of control. The Z and UK is given, and further factor is nature of risk. And that, again, that's been repeated in many cases. Finishing off with at H, jurisprudence of the operational duty is young, boundaries still being explored, the court's been intending to expand the circumstances in which the operational duty can be found to exist. Lady Hale at 99 to 104 speaks about the expansion and notes Mammadov at our page 665, 100. And then focuses on what the particular circumstances are at 101. And at E emphasises the question, well, will arise of what more individualised steps are required. This will depend upon whether the authority should have foreseen a real immediate risk and what more they could be expected to do. Our case, there was real immediate risk, and we know what they were expected to do because they didn't follow their own safeguarding guidance. At 102, she notes the special vulnerability of people suffering mental disorders, and we say that can be a feature in our case. And then poses the question, having considered the Savage case, but might the obligation stretch further than this? It seems clear from cases such as Mammadov that it can do so. So it can go outside the confinement situation, and says at between B and C, the court found itself unable to conclude whether they could or should have done more, and drew a contrast to the case of death in custody, where the burden would be on the state to provide a satisfactory plausible explanation. But there's no suggestion that the operational obligation to prevent suicide is limited to prisoners and detainees, and then reasons why. And then finally at 104, a summary of the duty at H. The state does have a positive obligation to protect children and vulnerable others from the real immediate risk of serious abuse or threats to their lives, of which the authorities are or ought to be aware, and which is within their powers to prevent. Whether they are in breach of this obligation will depend on the nature of the degree of the risk and what, in the light of the many relevant considerations, the authorities might reasonably have been expected to do to prevent it. That is a sufficiently widely drawn set of circumstances to say, for me to probably argue, there's a clear, it's clear from cases such as Mammadov that my particular facts, can fall within that rubric, and it is arguable that it applies. In the last few minutes remaining to me, I will simply mention, by way of footnote, Kemaloglu, which is mentioned, the skeleton is...
That's the Russian pensioners, yeah.
Yeah, well, the pensioners are under the Article 2 and 3.
They come along with the Turkish school children.
The Turkish school children, the 7-year-old who goes home, who...
They close the school because they
close the
and
school,
they don't tell the bus
snow,
to pick him up, and he suffers in the snow.
And that is how one views that, as whether it's a controlled situation, the duty of the school to at least consider that there were real risks to the child, and creators of the risk because they closed the school early and did nothing about it. The Article 2-3 cases on pensions and destitution essentially point to the fact that it's capable of applying Article 2 and 3 in circumstances where there's destitution, somebody's living on the streets for a number of weeks. There's some particular wording, if I could just finish off with, in Limbuela, at paragraph 56, that captures the sense of the point we're driving at from the Article 2 and 3 cases. And if I can just finish with that, Venezuela is to be found...
Tab 13.
Thank you. And 216 to 246. Is to be found in particular at the approach and practice. I'm afraid for time constraints, the point is that the person who in this particular situation is not able to work because they are prevented from working by reason of their asylum status. We draw an analogy in the sense that Jodie was unable to work by reason of disability. And these words at B through to D, the decision to withdraw support from someone who would otherwise qualify for support because he is or is likely to become within the means section destitute is an intentionally inflicted act for which the Secretary of State is directly responsible. He's directly responsible also for all the consequences that flow from it, bearing in mind the nature of the regime which removes the asylum seeker's ability to defend by earning money while they remain in that category. They can't seek employment for 12 months, etc., etc. And we characterise the withdrawal of benefits to a person in Jodie's particular situation who was unable to work through disability and illness as a positive act for which the DWP was directly responsible and for the consequences that flowed from it. And that state responsibility for that action is akin to the degree of control that I've indicated by reference to cases such as Mammadov and as distilled in Palestinian territory. That I've overrun, and I apologise for doing so, but I've tried to condense that final point into the key propositions which we seek to draw from the cases.
No, that's been really, really helpful, and any overrun is our fault, not yours, because we wanted to get submissions, and poor old Mr. Huff will have to live with 15 minutes less, but he doesn't mind. He's done a long skeleton. But thank you very much. Any questions at all? No, thank you very, very much, actually. Right, Mr. Huff, you've got half an hour now, and as I say, we've docked you 15 minutes, but if it's really necessary, you can get them back tomorrow, so don't worry too much.
Thank you, my lord. My lords, my lady, the coroner, who, as you've heard, is in court today, would like me first to acknowledge that apart from any legal issues, this is a tragic case and that Jodie's family have suffered a terrible and irreparable loss. It is important that she says that, yes, as well as mine.
Well, thank you very much. I'm sure Mrs. Dove will appreciate that.
The coroner would also like me to make clear that her position is not adversarial and that it is in particular not her intention to defend any of the clear, serious and admitted failings of DWP staff. As my lords and my lady have seen, she participates in these proceedings to explain her approach to the inquest and assist the court on matters of law. May I begin with some opening remarks before turning to submissions proper. Coroner's responsibility was to conduct the inquest into Jodie's death, and she sought to do that lawfully and humanely. Her view was, and for what it matters, it remains, this wasn't an inquest in which the procedural obligation under Article 2 was engaged, as in the Middleton case. If right, then it was her function to hold a Jameson inquest addressing the means by which Jodie died. She considered that the inquest she conducted was sufficient for that purpose and covered the evidential ground. And she is grateful for Mr. Hyam's careful statement that the appellant, Mrs. Dove, makes no criticism of her conduct of the inquest based on the material she had. It was a brief hearing, as my lords and my lady have seen, but that isn't unusual for an inquest into a death by suicide, where the medical cause of death and suicidal intent are tragically clear. The question in this statutory review claim is whether the interests of justice require a second inquest, and as I'll submit, that is a highly practical question rather than one bound up with a procedural examination. At first instance, there were 4 grounds of review. Insufficiency of inquiry on the premise that this was a Jameson inquest, insufficient inquiry on the premise that it was a Middleton inquest, that fresh evidence had emerged requiring a second inquest, and that a second inquest would probably result in a different conclusion. As my lords and my lady have heard, 3 of those grounds are no longer before the court. We make no criticism of that, but the case on appeal now advances the 2 grounds. First of all, that fresh evidence has emerged justifying a second inquest on the premise that it would be a Jameson inquest, and secondly, that a second inquest would be a Middleton inquest, and the fresh evidence on that premise justifies a further inquest being ordered. An important point which Mr. Hyam has helpfully addressed is what form the second inquest before a coroner, which the appellant is seeking, would take, what it would look like. Now, at first instance, as my Lady Justice Whipple said in argument, the case was that it should investigate the decision-making which led to the termination of ESA benefits. And for the note, that's paragraph 12A of the Statement of Facts and Grounds, Core Bundle, tab 12, page 149. That would naturally have meant a hearing over several days with multiple DWP witnesses, preceded by substantial disclosure from the DWP, not only about the process in Jodie's case, but broader procedures. The appellant, at least in relation to ground 1, appears now to be seeking a second inquest which would hear the factual evidence heard at the first inquest, plus evidence from Dr. Turner or another psychiatrist, the aim of that latter evidence being to try to determine the contribution of the withdrawal of benefits to Jodie's state of mind and her decision to end her life. It's also been suggested that a witness from the DWP might attend in order to say whether a PFD report was justified. Now, I'll turn to this a little later, but let me say now that it is far from obvious that a coroner could or should call a witness from a public authority to make quasi-submissions on whether a PFD report is justified.
But wouldn't the coroner write to the DWP and saying, I'm minded to do this, would you like to come and help? Is that how it would work?
Well, what a coroner will very often do is write a minded to letter of some kind and ask for representations on it. That wouldn't be in the form of evidence. That would be in the form of submissions or even representation by way of letter, which could then be considered. PFD process is ancillary, as the courts have put it, to the primary evidence gathering and inquisitorial function of the inquest. And so the coroner could certainly seek those representations, but it wouldn't be by way of putting a witness into the witness box. And it would certainly be wrong if this was suggested, to have a witness in the witness box simply so that the failings could be put to that witness and the witness, as it were,
I think they were thinking about, I got the impression of lessons learned. I mean, there's a catalogue of errors here, and the question is, have the lessons been learned? Have they told staff, for example, when we say support group and mental health flag, we mean it.
Yes.
When we say make a phone call, we mean make a phone call.
Yes, well, and
I don't know, it would be a disciplinary offence if you don't.
And your Lordship makes a very good point, because such are matters which often won't be within the scope of the inquest, because they will be looking at events which took place after death, and will tell the coroner about whether matters have changed, so that a PFD report is
Not
unnecessary. Now, the DWP would be expected, if the coroner was contemplating a PFD report, to write a letter saying either these were all individual failings rather than systemic ones, and here's the explanation, or there were some systemic issues and we've now addressed them. Here is the answer. But
anyways, you say, if I've got it right, the purpose of the inquest wouldn't be for a PFD report. It wouldn't have a live witness giving live evidence and so on. It would really ever be ancillary, and therefore that should not be the purpose for driving any decision on a fresh inquest.
Exactly.
Is that your submission?
Exactly.
Yeah.
But you wouldn't say that that a PFD report falls out with the purpose of an inquest, would you? I mean, whenever you have an inquest, you're always thinking about whether you need to have preventing further deaths, or a coroner would always be thinking about that. This is just mechanics, isn't it? About whether it's just this is something for a coroner down the line, isn't it? If we get there to decide who gets called, who does what, who wants to do what, that kind of thing.
Absolutely, but the coroner is concerned that the court doesn't make its decision on one basis, and then she's confronted with.
But what you're saying is it wouldn't be a reason for granting this application, ordering a new interest, that we thought there might be a PDF report. We've got to decide on the basis of effectively the fresh evidence whether there should or shouldn't be a fresh inquest. If in the course of that the coroner thinks she wants to address any questions about PDF, she or he will go about it in the way that they normally go about it in inquests. So that's basically, that can't be the driver. That can't tell us whether to grant it.
No.
Yeah.
There's also been the suggestion made that the ICE report might be admitted as written evidence. Now, if there were to be a further inquest, and the coroner considered that there were some points of fact in the narrative which she couldn't get from other sources, and the ICE report contained those, then that might be a justification for admitting those parts of the ICE report. But as I'll submit, an important point to make at this stage, it would not be right for the coroner to introduce the ICE report as evidence of failings in the context of a Jameson inquest, because the purpose of such an inquest would not to be to explore or make findings as to failings.
No, but it's fact here. It is an agreed fact. The department has accepted. They did not try to call, to telephone Jodie. And that's a fact, and that doesn't seem to be in dispute. It's also a fact that the policy document says they should try and call Jodie.
Yes.
Call somebody who's flagged and so on. So those are facts.
Yes, whether an inquest investigates those facts is a separate matter. Because
I'm sorry, I'm getting a bit confused. There isn't any problem, is there, in having the ICE report as your starting point? And this is the whole case against you, I think, as the starting point for the factual, the context, if you like, of what went on in relation to DWP and Jodie. Is there any difficulty with that?
Well, the coroner heard evidence as to the fact that the benefits were withdrawn, and about the Jodie's concerns about how that had happened, and of course about the timing of that withdrawal. Insofar as the coroner needed to go into the history of the communications between Jodie and the department, the ICE report could provide evidence of those. But in the context of a Jameson inquest, it isn't for the coroner to investigate DWP proceedings and say whether they got their decisions right or wrong.
No, but I don't think they're asking for that now. I mean, if this was only about the ICE report, they might have more of a problem, because we know what happened now. Jodie didn't know about the many failings that were done. Mrs. Dove didn't know about them until they admitted. Mrs. Dove was concerned about the way they were dealing with it later. And it was only when she complained about that all the other things came out. So no one is suggesting that precise knowledge of the mechanics of where the department failed went wrong, and nobody's suggesting that that's something that you're going to investigate. However, that's part of the background, because what has happened now, the relevant fresh evidence is the Dr. Turner report, and it's relevant fresh evidence against a background where you wouldn't be arguing about whether or not these things did or didn't happen, because the department has accepted it. So one problem is gone, what happened, we know, and the next problem, so the appellant says, is you want to join the dots up. You want to see if the stress created by the withdrawal of benefits however you describe it, fed into the mental state which fed into the suicide, is what the family is saying.
We respectfully entirely agree. So the critical question is whether the new evidence in Dr. Turner's report justifies a new inquest for the purpose of exploring, as well as what was explored in the first inquest, the question of a causal link between the withdrawal of benefits, whether rightful or wrongful, we know wrongful, and Jodie's decision, tragic decision to end her life.
Yeah.
And so what I've really been doing in these opening remarks is clearing away the ground to address the Dr. Turner report. The final opening remark I'd make, having made those points, is that the coroner respectfully considers that it's appropriate to deal with both grounds of appeal in any event. It's plainly necessary to deal with ground 2 if ground 1 is not accepted. But in our submission, it would also be right to do so if ground 1 were accepted, since otherwise the coroner in a second inquest would be in the impossible position of having a divisional court judgment saying Article 2 not engaged, but having a decision that permission to appeal that had been granted. The court would be guaranteeing a further judicial review.
Sorry, I haven't followed that.
Well, my lady, the position would be if ground 1, if the claim is allowed on ground 1 and ground 2 is not dealt with.
So you're just saying we should make sure we deal with it in the judgment?
Yes, ground 2.
Well, I think that's probably...
No,
okay.
I may be stating the obvious.
There's two things. Firstly, the coroner will need to know what to do with the inquest. But secondly, as you say, at the moment, the Divisional Court says Article 2 doesn't apply. If we are silent upon it, given that one judge, who should remain nameless, has said it's arguable, another judge might think, well, if she said it, if that judge said it's arguable, I better go on permission for judicial review. That's his point, I think. But it doesn't matter, because I think we're likely to be dealing with both.
Yes, having...
In fairness to my lady, it was dealt with on the public importance point rather than the other.
Oh, right, yes.
I'm sure.
But we won't create the elephant trap you fear.
No.
If in our judgment we deal, as I would always anticipate doing anyway, with both grounds that are argued.
Because the coroner needs to
I
know
may have
what
been
to
speaking in an excess of caution.
No, that's fine. It's important to get everything right, because I say if, because we haven't reached a decision, we do say there's got to be a new inquest, we need to know what's going to happen at the new inquest. Yeah, and the coroner does and the family do. Yeah.
With that by way of opening, I propose making submissions in 3 parts. First of all, the statutory framework and the legal principles governing the inquest and statutory reviews, then followed by ground 1 and then ground 2. May we begin with the statutory framework and the legal principles, and I'll take matters relatively briskly because I know that the court's very familiar. But may we begin with first authorities file divider 3. We see, first of all, Section 1 of the Coroners and Justice Act, which requires that there is an investigation in the circumstances in subsection 2, which includes that A, where the deceased died a violent or unnatural death, which of course includes suicide, so there must be an investigation and an inquest in any death by suicide. We move then to Section 5 on page 14. Lords and my lady may have looked at that briefly. That sets out the purpose of the investigation being to ascertain the answers to the 4 key questions: who, how, when and where. And then subsection 2, as my learned friend has rightly said, the statute says that where it's necessary to avoid a breach of convention rights, the how question is to be read as including the purpose of ascertaining in what circumstances the deceased came by his or her death. In our submission, that's a statutory codification not only of Middleton but also of Hurst. And then section 5.3 contains the prohibition on expressing an opinion on any other matter subject to the PFD report, paragraph 7 of Schedule 5. And then finally in the Act, page 16 of the authorities bundle contains section 10, which governs determinations and findings, which requires 1A, a determination of the questions in section 5, 1B, findings as to registration particulars, and then at 2, the prohibition on findings appearing to determine criminal liability of a named person or civil liability. So that's the statutory framework. May we then turn briefly to the Jameson case, because points have been made about the scope of a Jameson narrative, and some comments are made in that case on that subject. It remains the leading case on inquest determinations in cases where the Article 2 procedural obligation isn't engaged. As my lords, my lady know, it was a case about a suicide in custody. It's divider 6 of the bundle, page 24. And the general propositions begin at page 46. With proposition 1 stating that an inquest is a fact-finding inquiry to establish reliable answers to 4 important but limited factual questions. That's by letter G. Questions are then identified. Over the page at 47, proposition 2, how is to be understood as meaning by what means, not to ascertain how the deceased died, which might raise general and far-reaching issues, but how the deceased came by his death, a more limited question directed to the means by which the deceased came by his death. And then paragraph 6, proposition 6 at letter F. This is the starting point of all the comments about narrative conclusions and conventional inquest. There can be no objection to a verdict which incorporates a brief, neutral, factual statement. The deceased was drowned when his sailing dinghy capsized in heavy seas. The deceased was killed when his car was run down by an express train on a level crossing. The deceased died from crush injuries sustained when gates were opened at Hillsborough Stadium. Such verdict must be factual, expressing no judgment or opinion, and it's not the jury's function to prepare detailed factual statements. The Middleton case then expands that how question for Article 2 cases and only Article 2 cases. That is at divider 8. Another awful case of suicide in prison. Lord Bingham's speech begins at page 64. Paragraph 3, he refers to procedural obligation to initiate an effective public investigation where one of the substantive obligations has been or may have been violated. An agent of the state may be implicated. And then at page 66, paragraph 6, Lord Bingham adopts the approach of first asking what the Convention requires of the determination at the end of an Article 2 inquest, of an Article 2 investigation rather. He then surveys the authorities from McCann, Keenan, Edwards and so on, before providing the answer on page 71, paragraph 20, by letter B. To meet the procedural requirement of Article 2, an inquest ought ordinarily to culminate in an expression, however brief, of the jury's conclusion on the disputed factual issues at the heart of a case. So that's what the Convention requires. Question 2, he asks the question, he poses the question, does the regime for holding inquests meet those requirements? Then at paragraph 28, on page 73, by letter F, he observes that in Jameson, the Court of Appeal interpreted how as narrowly as meaning by what means. With that as context, then at page 74, paragraphs 30 to 31, he explains that a short form conclusion or a traditional Jameson conclusion may sometimes satisfy the requirement he's derived from the Article 2 jurisprudence. So if the question is, was it suicide or was it murder, or was killing lawful or unlawful, a Jameson conclusion will suffice. But that here, and in other cases of death by suicide, it may not suffice because the key questions are whether the procedures of the state fell down in enabling suicide to happen. In other cases, it may be enabling a criminal assault. So that's the reason why he says that there are some cases where the current regime is inadequate. And then then question 3, his final question, he asks whether the current regime can be revised. And then he goes on at page 75, paragraph 35, to say one change is required to interpret how's meaning by what means and in what circumstances. So the meaning, he said, had been, in paragraph 28, had been rejected. In paragraph 36, he deals with the change of approach which is required, which may involve inviting a narrative form of verdict, including the jury's factual conclusions. And he suggests various ways of doing that, including by way of questions or a narrative passage. Paragraph 37, he says that the statutory prohibitions and restrictions on conclusions must remain, before at H, suggesting a sample verdict. The deceased took his own life in part because the risk of his doing so wasn't recognised and appropriate precautions were not taken to prevent him doing so. He says that embodies a judgmental conclusion of a factual nature directly relating to the circumstances of death. So we see there that the conclusion may be judgmental in a narrative, in a Middleton case, but not in a Jameson case. Draw attention to those passages because, as my Lord will see, Lord Bingham's comments about the approach to be taken to obtaining a narrative in paragraph 36, which Mr. Justice Mitting cited in Longfield, are confined to Middleton cases. In Jameson cases, the conclusion must be brief, neutral and factual, expressing no judgment or opinion. I don't say for the moment that the Longfield conclusion itself, as suggested, was contravened that requirement, but that's an important consideration to bear in mind.
But the coroner, in his guidance, looks at Longfield, doesn't he, in the context of when you have a narrative verdict in a Jameson case?
Yes, but there is a passage in Longfield which my lords and my lady were taken to, where Mr. Justice Mitting said that these remarks at paragraph 36 were not confined to Article 2 cases. In my submission, as
Mr. Justice Mitting was wrong, you said.
he was wrong in that regard, and that's clear from Hurst. And I don't. One shouldn't be too critical of him for that, because Hurst then supervenes and makes clear that this is not a passage with general application.
But was the judgment wrong anyway? Could you have said that even if it was a Jameson, not Middleton case, that the poor lady fell out of the window and that hastened death by 19 hours?
In our submission, that was probably a legitimate verdict. It was at the outer reaches because it went into an underlying cause, but it was all about the physical mechanism and means of death. Now, I'll just make this point by way of prelude to some points that will follow. There are real difficulties about coroners in cases of suicide reaching conclusions not only about the fact that there has been suicidal intent, but what has brought about that suicidal intent. I'll go into these in more detail tomorrow. But quite apart from the question of whether it is possible on the evidence in an individual inquest to reach those conclusions. The question is whether a conclusion about the reason for the factors influencing the deceased person's motivation, question whether that's part of the means of death, is not a straightforward one. And
this is going to be critical. I mean, if you work back, the medical cause of death in this case is known.
yes,
We know the 3 drugs that were found in Jodie's body.
yes,
We know how they got there. They were self-administered. But the question is, what combination of things preyed on her mental state to cause her to do that? And what we need to know is, A, would it be open to a coroner to express views on that? Because if not, then that's the end of the Section 13 point. If it would be possible for the coroner to express a view about the range of factors leading to the mental state that caused Jodie to commit suicide, is a permissible thing for the coroner in principle to do, then we'd have to know whether or not it's desirable or necessary to do it here. That's where we're at the moment.
well, that's exactly the right structure in my submission. And the as to the first, it is a question of importance which goes beyond the primary coloured facts of this case. Though there are many inquests where, for example, a family is divided and one part of the family wants a finding that the suicidal impulse was driven by conduct of the other part of the family. There are cases where the argument may be put to a coroner that the suicidal impulse was due to the loss of a job, which and there's a desire to have that looked into and recorded in order to criticise the employer.
Can she do it?
Yes.
And secondly, does she have to do it?
Exactly. Exactly.
There's the 2 questions.
And it's because of that important question of principle that I've been going back to the starting point of the Jameson and Middleton authorities and the importance of focus upon the means of death, at least in a Jameson case.
I mean, there may be circumstances where it's not the mental state. A boy of 16 at a school, and the verdict is the boy hanged himself by going into a gymnasium which was unlocked out of hours and when the caretaker was not on duty, and hanging himself. That tells you what happened. It doesn't tell you whether there was fault in not unlocking the door or fault in not having a caretaker.
Yes.
So there must be circumstances, mustn't there, when you've got to say something about how the suicide arose, or where it wouldn't be impermissible.
Certainly as far as the authorities are concerned, the question is whether a proposed conclusion would fall within the rubric of the means of death.
Right. And we'll hear tomorrow the answer to that in this case, which is whether the various forms that Mr. Hyams put in the skeleton argument, I think there are at least 3, no, not a disrespectful comment, although it sounds it, there are 3 different ways in which he puts it, and you'll tell us whether all of those are prohibited or not prohibited, but in your submission desirable or not desirable, necessary or not necessary.
If, and I give this apology in advance, that given the coroner's particular position and not wishing to be adversarial as such,
Yeah.
we will be presenting a view on the authorities rather than fighting too hard for any particular position.
Well, that's very understandable and very commendable, actually. I'll forget tomorrow what you've told me today. And I'll be asking you the same question and shaking you by the throat if you don't answer it. But bear in mind that's what is on our minds, actually. And whilst by reference to the authorities, if we put the question in abstract terms, not in terms of, I know I'll do it tomorrow in terms of Jodie's circumstances, because I'm thinking about Jodie's circumstances all the time.
Yes.
But you can politely answer and say, well, my lord, I'm not going to do it in the way you've asked. For goodness sake, stop asking it. But I will do it in this way. Okay?
Thank you very
Well,
much.
thank you all very, very much. It's obviously a difficult and important case, actually. I know it's stressful. If at any stage you feel you don't want to sit through the legal arguments, we perfectly understand. If you want to sit and listen to what's going on, that's absolutely fine. Don't worry about what we're saying. We ask lots of questions of all the barristers, because It's the way we get at the bottom of things. It's just trying to get to the bottom of things. So have patience with us, and we haven't lost sight of why we're here, which was sadly the death of your daughter. So we haven't lost sight of that, actually. Okay? So I'll see you tomorrow morning, but you don't have to come here, Mrs. Dutt. But I'll probably see you, I suspect, at 10:30 in the morning, okay? And we've got time. We've got plenty of time. Thank you all very, very much.